Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hi, and welcome to our latest Doing Business in Australia podcast episode. At Hall & Wilcox, we work with both Australian and international clients, and we support our clients with their global opportunities. We have experts within the firm who do cross-border work in many jurisdictions, particularly the UK, Europe, China, Southeast Asia, and the US. My name's Mark Dunphy, and I'm delighted to be the host of this episode, where we're looking at migration and employment law. If you're planning to do business in Australia, you and your clients will need to know about our approach to migration and the intricacies of employment laws here. To join me in the discussion today is Chris Kunasingham, who is both my friend and head of our migration practice. Chris, I wonder if we could start by telling us a little at a high level about the different types of visas international employers can use.
Thanks, Mark, and for those kind comments as well. Much appreciated. There are various options available, but before jumping into them, I can start off by saying the immigration space in Australia gets a lot of traction based on what happens globally and specifically the US. Currently, there's a lot of chat about cost, given some of what's happened recently and the proposed $100,000 fee, which the current administration plans on imposing on H-1B visas. Those are the US work visas. And so coming out of that, we get many of our clients asking what's that cause and what's that the effect of that on the Australian visa system. And at this stage, our commentary is we'll have to wait and see, because with the US, we're not sure whether that fee will apply, but Australia tends to look differently. And we're also getting a lot of interest from, again, our clients looking at options outside the US because of that. So to give our clients a kind of feel for what the cost difference is at the moment, in the US, my understanding, a H-1B work visa would cost anywhere between $5,000 to $10,000 and it's similar figures in Australia, but with an Australian amount instead. So it's much cheaper to secure one of these visas. And then that leads to your question, Mark, like what kind of visas can employers use to bring people out here? The H-1B US equivalent is known as a 482 work visa in Australia. There's been some changes to it more recently, largely around timing. So where before it would take the Australian government about 3 to 6 months to process one of these visas, these days it takes about 3 to 6 weeks if the person's going to be paid above 142,000 Australian dollars. So 3 to 6 weeks. I would say most individuals coming across in certain spaces would earn above that. So that's been a positive development in terms of timing. So again, the 482 is the common visa most employers would use to send their people out here. And a second quick option, it's known as a 400 visa. Those ones allow a person to come up to 6 months. So if you have employees who you need to send out here on a short-term project, you want to be using this 400 short-term visa instead.
And with those short-term visas for shorter periods of time, is the processing time to deal with those applications quicker?
Correct. Those take approximately 4 weeks to process.
Okay, so that's good. So the system is nimble enough to look at different timings for different types of visas.
Correct.
Okay. I've heard a lot about the new talent and innovation category. Can you tell us a bit about that and how your clients are using it?
That's a great question, Mark, and I feel that's on the lens of what's happening globally. Immigration is, I find it an exciting place because we see countries compete against each other. And when one comes up with a policy, another country then tries to replicate it to try and see if they can get their hand in the pie. And this is the new term being thrown around, talent and innovation. It seems as if all countries want to attract the best. And so this is the Australian version of that. Essentially, it's something which the government has created this year, saying that if someone is highly skilled in a particular category, the category includes academics, crypto, healthcare, sciences, lecturers, and in certain STEM-based qualifications, the government wants to fast-track their applications. And rather than go through a temporary visa option, these individuals can move ahead and get their permanent residency status or green card status. Now, the uncertainty, though, like everything else, it's because it's new. It's only been created this year. We're still developing precedent in our dealings with the government to know what the threshold is on and exactly who qualifies. At this stage, there's just some commentary about what that looks like. So we're getting our applications in, but that's our sense anyway. That's our sense of what it's going to look like. It has to be someone highly skilled in their industry. I like to say to our clients, if I was to take your name, put it in Google, and if it comes out in Google Scholar, how much of your work is cited, that's usually then a good barometer on whether you can qualify for this visa. So someone who has lots of their work published, regarded, known in the industry, we would think they're a good candidate for this option.
And I imagine that's being used by tech clients particularly.
Correct. Tech seems to have the priority here, but also clean energy, Mark. So clean energy it's an up-and-coming space. And overnight, we're starting to notice certain engineers in the mining industry. So rare earths and the related fuels from that seem to be a priority as well.
And Chris, is the cost of those visas or the fees involved the same as with the 482s that you were talking about earlier?
Because these ones are going to grant a person permanent residency, they're slightly more, but not much more. The average government costs for these visas are about $5,000 to $15,000. So I know that's a wide range, but 5,000 or so is when it's a single person. But if that individual has spouses and children, the Australian government slaps on additional fees on top of it. So that's why I've given that range. It could go up to 15 sometimes.
Right. With my employment law hat on, Chris, I know that in Australia there are very significant record-keeping obligations on employers to keep records with regard to their employees and how they're engaged. And those obligations are set out at length in the Fair Work Act and require employers to keep details of people's start and finishing times, of total hours worked, of the award that people are worked on, their status within the award, and particularly overtime, and make sure that it's calculated correct each pay period. And something that's can be quite new to international clients, having employees in Australia, the onerous extent of our record-keeping obligations. What about in the visa space? What records do employers have to keep to deal with their employees that are on visas?
Sure. The good thing I can report is from a compliance perspective, this side of things has not evolved over the last few years. And the reason why I added that at the start is because we were recently at a conference, Mark, you and I, and we got to connect with a few of our colleagues in different countries. And the one thing I took away from different jurisdictions is the immigration authorities in those regions are increasing their audits and changing the rules, and that's not happened in Australia. To answer the question straight, an employer who brings someone out on a visa are expected to maintain their employment records, and that means their employment contract, a copy of their position description, hours they work. So if it's someone who has to actually time in how many hours they work a day, the employer is expected to have copies of that. They're also expected to retain copies of their employment documentation relating to salary, so their pay slips and their tax, not the individual's tax return, but more so what the company reports to the Australian Tax Office, how much they've paid that employee. The employers are expected to retain copies of that. So and I guess I can turn back the question to you, Mark. Do you feel that's any different to a company who is not sponsoring someone for a visa? Would they be expected to retain those similar documents for a non-sponsored employee?
What you've described is basically a mirror image of what would be required for a non-sponsored employee. We've been involved in matters for clients in the agricultural space, particularly, who have had a high number of employees on temporary visas to assist out in the fields particularly. And I know that there's an additional obligation on those employers to make sure that they have copies of visas and immigration details all up to date and accessible for inspection by people from the immigration department or from the relevant departments at the appropriate time. But so I think that is perhaps an additional obligation on those on visas, but otherwise I think it's probably a very similar regime.
Yeah, just to build on that, it's unique. I would add that it's unique to that industry. And the reason why is there is unfortunately a bit of a stigma that people who work within the farming industry may not always have an appropriate visa to be in Australia. There are high incidences of people who come in, say, on tourist visas, who do not have the right to work, allowed to remain up to 3 months, but find themselves working on farms because, number one, it'll probably be far away from where anyone's located. So they just think the likelihood of enforcement is lower. And also because it's a practice, unfortunately, which has gone on throughout the years. So it's going to filter its way into the system. So I agree with you there that certain employers in certain industries probably will face more scrutiny. And I would say the farming industry is one of them.
Thank you. Now, we act at Hall & Wilcox, as Chris, for many international organisations setting up operations in Australia, and Australian labour and employment laws are very different to those in most other countries, particularly in the US, where they have employment at will, for instance, and here we have significant unfair dismissal laws. And here we have very strict laws set out in the Fair Work Act on the obligations of employers, and some pretty significant penalties for non-compliance with those obligations. For instance, there was a case in the federal court. A law is reasonably clear that employers need to make payment of anything that they owe to employees on cessation of employment at the end of the employment relationship. What many employers over time have done is just waited till the next pay run and paid notice periods and annual leave and long service leave all out at that time. There was a case in the federal court recently, though, where an employer did that and paid the leave entitlements out at the end of the next pay run, and the employee complained about that on the basis that they were formally due on the last day of employment. And the federal court agreed, or federal circuit court rather, agreed with that employee, and the employer received a penalty of an additional $18,000 for being only a few days late with regard to paying. So the penalties for non-compliance with our pretty strict regime can add up very quickly. And so we've had to advise our clients to change the way that they comply with those obligations now and do things very differently than they did before that Fair Work case, or that federal court case, which has been quite difficult for some employers. What about, I'm interested to know though, in the migration space, what sort of penalties there can be for non-compliance and how employers we can assist employers mitigate risks?
I've got a follow-up question for you there, but we'll circle back to it after I answer your question. So what can the penalties look like? This is a wide range. The range is unbelievably wide for that answer. It depends on the penalty units associated with the offence or the breach, but it ranges anywhere from 250 Australian dollars up to $19,000 per incident. So there's a wide range, and obviously it's applied based on discretion. Things which employers could get done for include, say, if you sponsor someone for a visa and you told Home Affairs or the Australian government that you were bringing a person out here to do a particular type of position or role to fill in, and subsequently was discovered that they were doing something different altogether, there is a fine involved in that. Or if you brought someone out here, you agreed to pay them a set rate, as an example, $100,000, but for whatever reason, payment systems, or you didn't follow through with that payment for whatever reason. Again, we can circle back and I can throw to you for some strategy options there. But say if the payment salary fell below the amount you said you were going to pay someone at, there is a significant fine involved in that as well. And the current environment is, even if the salary is only minuscule in compared to what was agreed, so even if it's, let's say it's $500 below what you said you were going to be paying them on an annualized basis, the Australian government's taken a pretty hard stand with that. So the fine which comes out of that is way more significant at times, in my experience, than not the actual loss in terms of the actual salary itself. I guess, Mark, in your experience having to advise our clients, what can they do to try and avoid situations what you've just described there?
Look, they have to know, employers need to know what their obligations are, and they need to know that increasingly there is nothing around the margins, that there's no grey or rubber in it. They just need to comply with those obligations. So we put many organisations in touch with accountants to make sure that they set their systems up correctly. Accountants will typically make sure that the right payroll system is put in place. Yep. And then we will often advise employers on their strict obligations according to to awards, etc., and assist with that. But it will typically need an Australian system set up and adopted from the international system to make it work for them, and employers need to realise that, and that's the best way for them to comply. You mentioned a few times about employment contracts, Chris. Is there anything specific, or can the same employment contract that we would use for an Australian national employee be used for somebody on a visa?
Mostly yes, but when someone is out on a visa, we would advise our clients to add more customized clauses as a schedule, usually to an employment contract. And the reason why that's done is so that it's clear to the employer as well as the employee that there are certain obligations and a bit more requirements coming along when you hire someone on a visa. So again, it's largely similar, but there are parts of it which we would add to, and we usually do that by adding a schedule to the contract itself.
Yeah. And does the employment contract need to be filed as part of the visa process with the department?
Correct. That's right. We do file it, and when we file the employment contract, what the Department of Home Affairs is looking for is the type of position someone's going to be performing out here, how much they're earning, and also examine some of their basic employment terms, such as their entitlement to, say, restraints, work from home, probationary period, termination rights. So the Department of Home Affairs do want to examine those requirements as well. And Mark, are there some upcoming changes to these areas from your experience going forward?
Not so much with regard to contracts, Chris, but there are certainly some changes on the horizon with regard to, in the employment law space generally, and obligations that employers are going to have. In Victoria, for instance, where you and I largely practice, the government is looking to mandate working from home a couple of days a week for all employees. Now, there's some serious question about whether the government actually has the ability to do that, but politically it's proving a very popular move for the government, so they're going to move heaven and earth, I think, to find a way to do it. It'll probably be grounded in discrimination law, is how we think, and then there'll be scope for a lot of argument about what jobs are appropriate to be done on a working from home basis, or at least a couple of days a week, and which aren't. The other big change that's being talked about, and there's been a lot of work done, is with regard to restraints of trade. And there's talk about legislating them out of existence effectively, or making them completely unenforceable, to free up the mobility of labour. And there are strong arguments both for and against that. Employers, when we're drafting contracts for employers, we will usually include restraints of trade clause to stop people moving to competitors and stop people poaching clients and staff from their employers, and also allowing employers to protect the goodwill that they've built up in the business. The Increasingly, though, those clauses are being used for all employees, even lower level employees, and there's been many cases where those have been found to be unreasonable and thus unenforceable, particularly for junior employees. But I think that it is likely that there will be some significant movements in this term of government from the federal government of trying to legislate out restraints of trade, and how that will impact on existing restraint clauses will be interesting to see, whether they'll be grandfathered out or whether they'll just be ruled unenforceable as a whole. What about in the migration space? Is there anything that's any significant changes being mooted there?
Yeah, not based on what you've described there, Mark. I think the way the immigration system works in tangent with the employment laws out here is the employment laws make certain adjustments and policies, and the immigration policies try to mirror those instead. So what you've just spoken about a person's right to work from home and restraint periods, whatever ends up happening, that'll be also interesting, by the way, because immigration is a federal state legislation. And so it'll be interesting to see if someone ends up having to work in Victoria, where then they have the right to work from home, and how the immigration policy and lens is going to look at that particular person versus, say, if they were working in Sydney or in New South Wales. That's something interesting to just observe. But at this stage, from an immigration perspective, we'll probably take the lens on what's going to happen with the workplace and employment side of things before there's something which comes from that.
Right. I think we're nearly out of time, Chris, so I think we're going to wrap it up there. So thank you very much for your time. I'd like to thank everybody for listening today. And as always, please get in touch with us if you have any questions. You can find our details on our website, which is hallandwilcox.com.au, or connect with us on LinkedIn. And if you enjoyed today's episode, then please rate, review, or subscribe to our podcasts wherever you get your podcasts from. Thank you very much.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.